My name is Allison, and I'm an Info Services Librarian at the Arlington Heights Memorial Library. I'm joined tonight by my colleagues, Info Services Librarian Barb, and Bilingual Advisor Catalina, who will assist with any Spanish interpretation tonight. I'm delighted to introduce you to tonight's speaker, Nareen Kim from the North Suburban Legal Aid Clinic. Nareen has more than 2 decades of legal experience. She has extensive experience in all areas of housing law, including private and subsidized eviction defense, housing choice voucher terminations, reasonable accommodations, and conditions issues. Nareen worked at the Legal Aid Society of Metropolitan Family Services, where she represented low-income tenants who were being unlawfully evicted or at risk of losing their subsidies. Nareen also worked as a staff attorney at Legal Aid Chicago, representing indigent clients in family law, housing, employment, and consumer issues. Prior to her work in civil legal services, she was a criminal defense attorney at the Lake County Public Defender's Office and the Evanston Community Defender Office. She received her JD from Northwestern University and her BA in political science from the University of Illinois at Urbana-Champaign. And with that, I will turn it over to you, Nareen.
Thank you so much, Allison. And thank you all for being here this evening. It's a beautiful day outside, so I appreciate you spending some of your evening with me. Right now, we are in a housing crisis, and because of that, there's a heightened awareness of all of the housing issues that people are facing, especially here in the suburbs. So I am a housing attorney, and I represent tenants who are facing problems with their landlords, and this can be an eviction, a lockout, a problem with repairs to their unit. So I wanted to talk to you today about tenants' rights, basic tenants' rights specifically. And then I also wanted to introduce you to the new Cook County Residential Tenant and Landlord Ordinance that just got passed for tenants in the suburbs. And we're going to talk also about the eviction process in Illinois. And then we're going to talk about how COVID has been affecting the eviction process, and we'll talk more about the moratorium here in Illinois. So let's get started. So first of all, I work at the North Suburban Legal Aid Clinic. We are a legal services agency. That means that we provide free legal services. We help out people in the areas of immigration, domestic violence, and housing. So as we talk about these housing issues, if you if you yourself or you know somebody else with housing issues, they can contact our clinic. We'll talk at the end a little bit more about the specific housing issues that we can help with and our eligibility requirements. So let's first talk about basic tenants' rights. First of all, when you're trying to find the right unit to rent, it's really important to make sure that you ask your landlord the right questions. And these are just basic questions that you should not forget to ask. What is the monthly rent? When is it due? How do you pay rent? Are there late fees if you pay your rent late? How long will the lease be for, and when will the lease start? Who pays for utilities? And what are the average monthly costs for utilities? What is the security deposit? Is there a move-in fee that's non-refundable or refundable? And who would you call if repairs are needed? The other really important thing is just to talk to previous tenants, the tenants who currently live there or who may have lived there before, the neighbors around. Does this landlord make repairs? Have they had any problems with the landlord? How's the soundproofing between apartments? I mean, this is a big issue that many tenants have and only encounter after they've already moved in. So ask some questions beforehand, and it will make you choose the right apartment for you. You should ask for a written lease to be signed by both your landlord and yourself. An oral lease is valid, but a written lease is better. Because it makes it really clear for both the landlord and the tenant what the rules are. And so you should really make sure the following things are in the lease: the names of all the tenants who will be living in the unit, your landlord's first and last name, phone number, and address, the start and end date of the lease, monthly rent amount, when the rent is due, and the amount of late fees, the security deposit amount, who pays for the utilities, is it the landlord or the tenant, and how much notice does the landlord need to give to enter the unit. Make sure that your landlord gives you a copy of the signed lease. When you move in, it's a great idea to do a walkthrough with your landlord. That's to make sure that everything is in good condition, and you should make sure that the appliances are working and that the utilities are also working. It's also a really good idea to take pictures and video of every room when you first move in. You want proof of the condition of your unit when you moved in, and that's just in case later there's a problem and your landlord says that you caused damage to the unit, but the damage pre-existed you. During your tenancy, make sure that you keep written proof of your rent payments. And if you pay cash, you can ask your landlord to give you a receipt. If you and your landlord agree to any changes to the lease, make sure that any changes you make are in writing. You and your landlord should both sign it, and you should keep a copy of this. If your landlord sells the building while you're living there, you do not have to move. The new landlord will take over your existing lease, and the security deposit will also carry over from your old landlord to the new landlord. Make sure you get your new landlord's name, address, and phone number, and make sure you know where you should be making the rent payments to your new landlord. If you have conditions or repairs problems in your unit while you're living there, some good tips. First, notify your landlord of the necessary repairs in writing and keep a copy. Take pictures. You can consider calling your local building department. And if the conditions are serious enough, consider moving if the conditions allow you to break your lease. A lot of people ask me about what repair and deduct and what does that mean. Repair and deduct is for smaller repairs that a tenant could get fixed themselves. So if your landlord isn't making a repair, you could give written notice to your landlord that they have 14 days to make the repair, or if they don't, that you will make the repair yourself and deduct the cost of that repair from your next month's rent. Then the tenant has to pay for the repair and then deduct the rent and deduct the cost from the rent. And the tenant can only deduct $500 or half a month's rent. Now, one thing to be really careful about for a repair and deduct is that sometimes this may lead to your landlord filing an eviction for non-payment of rent. Because you don't pay the full amount of rent the next month, they may disagree that you're allowed to do this. And so that could lead to an eviction case being filed and having to resolve this issue in court. The Immigrant Tenant Protection Act is an Illinois law that prevents a landlord from threatening to evict a tenant or evicting a tenant because of their immigration status. So if you are an immigrant, your landlord cannot use your immigration status to intimidate you or to force you to move. And your landlord may not threaten to call ICE, increase your rent, evict you, or shut off your utilities for exercising your rights as a tenant. You have the right to live in a safe, reasonably maintained home and to ask for repairs, even if you are an immigrant. So what is the Safe Homes Act? This is an Illinois law that allows victims of domestic violence or sexual violence the right to break a lease without being responsible for the rent that accrues during the rest of the lease term. It can also allow a tenant to change the locks of their unit. The requirements to break your lease are if there is an credible imminent threat of domestic or sexual violence against the tenant or a member of the household at the premises. And the tenant must give written notice to the landlord prior to or within 3 days of vacating the premises. So ending the lease, your lease should state when the lease terminates and how much notice your landlord needs to give you that they will not be renewing your lease. So if you're a month-to-month tenant, Without a lease, your landlord must give you 1 full month's notice to terminate your tenancy. And your landlord does not need to renew your lease. When the lease ends, your landlord does not have to give you a reason why they are not renewing your lease. They can just choose to give you notice that they are not renewing. So some steps to get your security deposit back after you have moved out. First, make sure that you have moved out all of your possessions, clean the unit, do a walkthrough with your landlord if that's possible, take photos or video of the empty unit, return the keys, and make sure your landlord has your forwarding address where to send this security deposit. So I want to talk to you about the Cook County Residential Tenant Landlord Ordinance. This is a new ordinance that gives rights and protections to renters who live in the Cook County suburbs. So this applies to all suburbs in Cook County except for Evanston and Mount Prospect, which have their own ordinances. And it's not applicable in Chicago either because Chicago has their own separate ordinance. This just passed the Cook County Commissioner's Office on January 28th of 2021, and it will go into effect June 1st of 2021. So what units are covered? The Cook County RTLO covers almost all residential rental units, and that includes mobile homes, Section 8, and HUD housing. There are some exceptions though, and some units that are not covered under this ordinance. So it does not apply to units in owner-occupied buildings with 6 or fewer units. So if you live in a 3-flat, for example, and your landlord lives in one of those 3 units, you would not be covered under the Cook County RTLO. It also does not apply to a single family home or a condominium if the owner is only renting that one property and either the owner or an immediate family member of the owner has lived there in that property within the last year. The Cook County RTLO prohibits illegal lockouts, which are when a landlord tries to prevent a tenant from living in or accessing their unit. The Cook County RTLO goes into effect June 1st of 2021, but the lockout protections are already in effect as of January 28th. So what are examples of an illegal lockout? It's when a landlord changes, removes, or adds locks, removes or blocks doors or windows, removes the tenant's personal property, removes necessary appliances or fixtures, interferes with or cuts off utilities such as electricity, gas, heat, hot water, or threatens to do any of these things. So lockouts are illegal. The landlords must follow the actual lawful legal process and go to court to get an order evicting their tenant. And only the sheriff's office is allowed to enforce an eviction, and only a sheriff's office can therefore force a tenant to move out. So if you are a tenant and you're experiencing an illegal lockout, you can call the police or 911. You could call your local building department or your township or municipality. You can also get legal assistance or contact a housing advocate. And under the Cook County RTLO, tenants can sue and get access back to their unit and also 2 months rent or twice the actual damages and attorney's fees. So the Cook County RTLO also sets limits on the amount of fees a landlord can charge a tenant. So some limits are on, for example, late fees. They're capped at $10 for the first $1,000 of rent and then 5% of the rent amount. Security deposits will now be capped at 1.5 times the monthly rent. And move-in fees must be reasonable and also related to the costs of the tenant's actual move-in. The trend has been towards charging non-refundable move-in fees instead of asking for security deposits, but this new RTLO will prevent that unless there are actual costs to the move-in. So under the Cook County RTLO, landlords have the right to enter their tenant's unit, but they must give proper notice and have a reason to do so. So landlords are not allowed to enter just to harass their tenants. So what is reasonable? Landlords must give their tenants 2 days notice that they're going to come into the unit. And reasonable hours are between the hours of 8 a.m. to 8 p.m., but you can agree on other times. Reasons that a landlord might have to enter the rental unit are to make necessary repairs, alterations, or improvements, to show the unit to prospective units within 60 days of the lease ending, showing the unit to prospective purchasers, inspecting as required by a government agency, or just doing their own inspection to make sure that a tenant is complying with the lease. So just a note to remember is that in case of an emergency, no notice may be required. So for example, if there's a problem with the plumbing and there's a flood in the unit, the landlord may have the right to immediately enter the unit without 48 hours notice because they need to fix an ongoing issue. The Cook County RTLO also requires landlords to include certain information in the lease and to notify their tenants of certain situations. So we talked a little bit about what are good things to have in the lease, and this RTLO now requires certain things to be in the lease. And that includes, first of all, attaching a summary of the Cook County RTLO, and also making sure they include things like the owner or agent's name, address, and telephone number, the estimated utility costs for a unit, if known by the landlord, and also disclosing the past year's building code violations and any lead hazards. So landlords are required to notify their tenants if the utilities may be cut off. And that's like if the landlord hasn't paid the utilities for the building. If there's a new owner to the property, or if they are in foreclosure, they must notify their tenants. Also, there's a new requirement that a landlord gives 60 days notice if they are not planning on renewing their tenant's lease. So I want to move over now and talk a little bit about the eviction process in Illinois. And the eviction process in Illinois starts with a written notice that a landlord gives their tenant. And then after that, there's the filing of an eviction case in court. And then there's a court date where a judge may decide what happens. And only after that could there be a forced eviction, which is when the sheriff comes in and forcibly removes a tenant from their unit. So we're just going to talk a little bit about this process in a little bit more detail. The notice, before starting an eviction case, the landlord must give the tenant a written notice to terminate their tenancy. And usually the kinds of notices that people see are a 5-day notice for non-payment of rent, a 10-day notice if there are lease violations, and a 30-day notice to terminate a month-to-month tenancy. So just keep in mind for people who live in subsidized housing where a portion of their rent is being paid, there may be other specific requirements for what type of notice is needed and how the notice must be given. And also specific local ordinances may have other specific requirements. So this is just a sample 5-day notice. And I just highlighted this because usually what's written down here is the amount of money that somebody owes their landlord, like how much they're behind. And there's usually this language that is very confusing to people. So I just wanted to read it and explain it. The language is basically that you're notified that there's a certain amount that you owe. And unless you make the entire payment before the expiration of 5 days after service of the notice, your lease of the above rental premises will be terminated immediately. And many people, upon reading this, think that that means that after that 5-day period, they have to leave their unit right away and that their landlord has the right to throw them out on the street. And that's not what this notice means. It just means that after this 5-day period, the landlord then has the opportunity to file a case in court. And so that's the next step of the process. Only after this notice period ends, the landlord can then file an eviction complaint with the clerk's office. And along with the complaint, they file a summons. And so the sheriff's office will be the ones who will take the complaint and summons and go out and try to serve the tenant with these court papers. It usually costs in Cook County about $350 for a landlord just to file the case, just to get it started. If you want to find out more about court information about a specific case, if you live in Cook County, you can go to the Cook County clerkofcourt.org website, and you can look up case information there. For Lake County, you can go to the Lake County Circuit Clerk website. So basically every county has their own clerk's website, and that's where you would go to look up more information. So the court process starts with the trial or return date. So if a tenant has been served with a complaint and summons, they should go to court, and they could potentially request a continuance to get an attorney, or that could be their trial date. And a tenant can have a trial and raise defenses such as waiver, defective notice, a warranty of habitability issue. I mean, there are many different types of defenses that a tenant could raise. And oftentimes most people work out a settlement though, and that's another option, that a tenant can work out a settlement with their landlord, such as a repayment plan for a non-payment of rent situation, or a probationary period, or moving out with a compliance status date, meaning that if you move out, the case will be continued. If you've moved out by that next court date, the case would be dismissed. So if the tenant loses or agrees to it, the court will order an eviction order. And the court, the judge, can enter a money judgment, and the judge can also issue an order giving possession back to the landlord on a certain date. This is just a close-up of that previous eviction order. And I've just circled, these are the important parts to look at in an eviction order: the date the tenant must actually leave the property, and also the total money judgment amount, the total amount that they owe. And that will include both maybe the rent that they owe and also fees and court costs. So if the tenant does not leave by the time that's listed in the eviction order, the landlord can then have the sheriff enforce the eviction. And only the sheriff's office is allowed to enforce an eviction, not a landlord on their own. The landlord has to take their papers over to the sheriff's office, and then the sheriff's office will put it on the schedule and come out and be the ones to physically remove a tenant. In Cook County, there are no evictions that are enforced when the weather is below 15 degrees or is severe weather, and also between the dates of December 17th through January 2nd. You can go to the sheriff's eviction schedule in Cook County to find out when your specific case is sort of on what date they're going to actually come out. You can go to the www.cookcountysheriff.org to look at the eviction schedule for the week. Just having an eviction case filed against you in court can create a problem, because the eviction case will appear on the tenant's credit report. So it can prevent you from being able to rent again in the future, because it will show up on that background screening that many landlords will do. So what about sealing of an eviction court case? Court records can be sealed, but only if the tenant requests it and only if the judge agrees to it. So usually the judge will only agree to seal an eviction case if the tenant wins their case, or if the landlord agrees to it as part of a settlement. However, it really is up to each individual judge. It's up to their discretion to determine whether or not a case should be sealed. And even if the case is sealed, unfortunately, some eviction cases can still show up on a tenant's credit report, even if that case has been sealed, and even if they have won their eviction case. So we've talked about the eviction process under sort of normal times. But right now things are not so normal. So I really think it's important to just tell everybody about what's going on right now because of COVID, because things are very different. So first of all, what can a tenant do if they're having trouble paying their rent because of COVID? And if you are a tenant who's having trouble paying rent, you are not alone. Many tenants right now who have never before had problems paying the rent are facing that right now because of a loss of income because of COVID. So for tenants who live in subsidized housing, if their income has decreased because of COVID, they can request, and if their subsidy is based on their income, they can request an interim recertification and for their rental portion to be reduced. But for tenants in private housing, they're in a much more difficult situation. So tenants can talk to their landlords about a reduction in rent during COVID because of a loss of income, or they could ask for a payment plan. Any agreement that is made should be done in writing. But really, what most tenants, what they can do to get help is to apply for emergency rental assistance. So where can a tenant go for emergency rental assistance? It's a little confusing, as many things are right now. There are many different sources for rental assistance. So I'm just going to outline some of them, and then we'll talk more specifically about some of these. So at the state level, there is emergency rental assistance through the Illinois Housing Development Authority. They also people call it IDA. And IDA had a rental assistance program last summer in August of 2020, and they're going to have a really big emergency rental assistance program that's going to open soon. I believe the projected date is mid-May. The Illinois Department of Human Services is also going to have emergency rental assistance, but their program is going to be a little different. It's going to be referrals through agencies. On the county level, if you live in Lake County, for example, you can call 211. For Suburban Cook County, there is a call center, and that number is 877-426-6515. If you live in the city of Chicago, there are also different resources. For Chicago residents, you could contact 311. And there was also going to be a City of Chicago Department of Housing rental assistance program. It's not open yet, but it's going to drop probably pretty soon. There were also other resources where tenants could get rental assistance, and that may be through your township, your municipality, the city or town you live in, could be through the school district, or for other community organizations may offer rental assistance. So for Lake County, I mentioned this already. If you're a Lake County resident, you could contact 211. The Lake County Federal Emergency Rental Assistance Program opened April 5th and is ongoing. So I already talked about the Illinois Housing Development Authority IDA program, which will administer rental assistance and utility assistance. Again, the anticipated launch date of that is mid-May 2021. And you can go to the IDA website, ihda.org, to find out more about their program. And also, once it is open, there will be an online portal through that website where people can apply. You can also go to www.chi.cook.il.renthelp.org. This will outline 4 different programs, the 2 from the state of Illinois that I talked about, and the City of Chicago program. And there are all these different rental assistance programs, which will all offer up to 12 months of unpaid or past due rent and up to 3 months of future rent. This is just a program summary of those 4 programs. Again, the IDA state program, the Illinois Department of Human Services program, the Suburban Cook County program is already closed. That was open in March, but it is already closed. So you could disregard that. And then also there's information about the City of Chicago Department of Housing program. So people not only need rental assistance, but also utility assistance. And so some of these rental assistance programs will be offering utility assistance as well. And separate from that, you can also seek utility assistance through LIHEAP, the Low Income Home Energy Assistance Program, which will help with heat, gas, electricity. To apply for LIHEAP, you would go through your local administering agency. Need to do that before May 31st of this year. For Cook County suburban residents, the local administering agency is CEDA, C-E-D-A, and you can find more information at their website, cedaorg.net, or by calling 800-571-2332. And for folks who live in Lake County, that they would be contacting the Community Action Partnership. So can tenants be evicted for not paying rent during this COVID crisis? No, right now, tenants cannot be physically evicted for not paying rent. We do have an eviction moratorium in Illinois. Right now, it is through May 1st of 2021. It is an order that is given through the governor by executive order, and his executive orders can only be for 30-day periods. So the moratorium has been in effect since last March of 2020, and it will most likely be renewed again when it expires May 1st. However, again, it can only be for 30-day periods. So people are always a little confused or worried because they think that the moratorium is going to get lifted. But it will likely be extended for some time because there is this huge amount of rental assistance that's going to be coming down to help both tenants and landlords. And so it is unlikely that the governor will lift the moratorium until that money has been dispersed. Keep in mind too that the federal CDC moratorium has been extended to June 30th of 2021. So it seems quite likely that the Illinois state moratorium will continue for at least that long, if not longer. So, and because of the Illinois moratorium, eviction orders will not be enforced by the sheriff's office unless a tenant poses a direct threat to the health and safety of other tenants or an immediate and severe risk to property. So non-payment of rent would not be included in these categories of direct threat to the health and safety of other tenants or an immediate and severe risk to property. So if you do owe rent, you could not be forcibly evicted right now. How can a landlord file an eviction case against a tenant right now? Well, this is different and maybe. So under the Illinois moratorium, eviction cases can be filed in certain situations. So for example, eviction cases can be filed if a tenant owes rent and does not give their landlord a signed declaration and are not considered a covered person under the moratorium. Or for the health and safety exception, if a tenant poses a direct threat to the health and safety of other tenants or an immediate and severe risk to property. So all other eviction cases cannot be filed right now. And that includes cases where a tenant has stayed past the term of their lease. So who is a covered person and who can sign a declaration? A covered person is basically a tenant who can give their landlord a declaration which attests to the following: that they have are lower income, that their annual income won't be above $99,000, and that they've had a COVID loss of income. That could be because they've lost work, they've had reduced work hours. Also, you have to show that you've been making partial payments, that you're using best efforts to make some timely partial payments, and that your circumstances permit. The other requirement is that If you were evicted, you would likely become homeless or have to share housing. So how does a tenant get a declaration, and how should they give it to their landlord? So the landlord is actually supposed to give their tenant a copy of the declaration to complete 5 days before they issue any type of notice of termination and before they file an eviction case in court. So in case they don't, though, tenants can get a copy of the declaration form. You can get it at the IDA website, ihda.org, and you can give it to your landlord yourself. Tenants should give their landlord the declaration in a way that they have proof that they gave it to them, and they should keep a copy too. And keep in mind that every adult member of the household must submit their own declaration. So all new Cook County eviction cases are being diverted through what's called the Early Resolution Program. And this will offer tenants and landlords an opportunity for mediation and for some free legal advice. So if you want any more information about this early resolution program, because you have a case, an eviction case in court, you can go to the cookcountylegalaid.org website. So again, this is an opportunity then for mediators to provide free services to try to help landlords and tenants work out their issues. And also just to give some brief legal advice to tenants and landlords. This does not involve any direct representation in court, just out of court advice. So we talked a little bit before about the eviction process in Illinois under normal times, and I've kind of just added some things in that are COVID related. So again, the landlord must give a declaration to their tenant 5 days before serving any type of notice of termination. Cases that can be filed right now in court are non-payment of rent cases where a tenant could not sign a declaration, and also those health and safety, immediate and severe risk exception cases. Any case that goes to court first gets diverted through the Early Resolution Program in Cook County. And tenants who can be forcibly evicted are only those who fall under the health and safety and immediate and severe risk exception. So if you or someone you know has a housing legal problem, you can contact the North Suburban Legal Aid Clinic. So we do have some eligibility requirements. You must be income eligible, and that means that you have to be below 250% of the federal poverty level. So that usually means for one person an income of around $31,000 or below, and for a family of 4, it's roughly $65,000 or below. We can help tenants who live in either private or subsidized housing. And we help people who live in Lake County or North Suburban Cook County. If there's an eviction case, it must be at the Skokie, Rolling Meadows, or Waukegan courthouse. And we can also represent tenants who are undocumented. So what are like the kinds of cases we help with? Really any type of landlord-tenant dispute, eviction cases, any type of conditions or repairs issue. If you need to break a lease, rental assistance applications, if you need help understanding where to go or how to fill out the application because you don't have the technology to do so, we can also help with that. Any illegal lockout situation where your landlord isn't going through the legal process of filing an eviction, but instead trying to illegally lock you out, we can help people with that. Return of security deposits, any type of termination from subsidies, and also any type of reasonable accommodation issue if you are disabled and there's a problem relating to your disability. So how to contact us? You can contact the North Suburban Legal Aid Clinic by giving us a call. You can reach us at 847-737-4042. And you can also go to our website at nslegalaid.org and also reach out to us by emailing us at info@nslegalaid.org. Our office is in Highland Park. But we are doing most of our work remotely. So we are doing telephone interviews and people are not meeting with us at the office right now. So that is the presentation that I wanted to share with everybody, but I am happy to take questions that people might have about anything I talked about or any other type of housing issue that they want to bring up.
Well, first of all, thank you so much, Nareen. That was really informative, super helpful. I'm excited about the content that you offered our customers. We don't have anything coming into the chat, so I do want to encourage folks, if you have any questions, now is the time to ask. You can raise your hand. I'm happy to unmute you if you're more comfortable speaking out loud, or go ahead and use the chat, type your questions in there, and I'll be happy to read those out loud on your behalf. So let me just give it a moment to make sure we don't have any questions. Feel free to take advantage of this opportunity.
I'm going to go ahead and stop the share.
Great.
And I think Allison also already mentioned that the entire PowerPoint presentation that I just provided is also available as a PDF, so you can use it as a resource.
Yeah, I will actually go ahead and put that into chat again so that everyone has access to that link, hopefully. Do we have any questions tonight? Anything at all relating to housing, of course.
I can also take other questions. Okay, well, if people don't have questions, that's fine. But if you think of something later, like I said, please feel free to reach out to the North Suburban Legal Aid Clinic. We do offer free legal services. We have staff who are bilingual, who can speak Spanish and Polish and Korean, but we can also use an interpreter for any other language that you may speak as well.
Thanks, Nareen. We'll give it just one more minute. I do want to make sure everyone has an opportunity. And it's like Nareen said, it's fine if you would prefer to take this off webinar. Some of these conversations can certainly be difficult and sensitive, so we want to be respectful of that. But if there are no questions tonight, Nareen, once again, thank you so much for taking the time to join us tonight and talk about this. Oh, wait, we have a raised hand. I'm going to go ahead and allow you to talk. So you should be able to unmute yourself now and ask your question.
I am Gundi. My landlord increased last year in May my rent by $60. Was this legal?
Well, it is if you don't have a lease or if you have a new lease, your landlord is allowed to raise your rent. You don't have to agree to it if you don't want to. But if you have a new lease that your landlord wants to increase the rent on and you agree and sign it, yes, it is legal for your landlord to increase the lease. Increase the rent between lease periods.
Wow.
Yes, and there isn't actually, there's no standard on what rent can be. And your landlord is allowed to increase rent and is allowed to increase rent to the amount that they want to. I think it's based on whether people will accept that.
My rent was increased in October 2019, and then in May he informed me via SMS the rent going by $60 more. This means now I pay begin. I am a tenant, $80 more for this one-bedroom apartment.
Yes, like I said, if you're not within a specific lease term, like if you have a lease that's already in effect, your landlord is not allowed to raise your rent within that lease period. But if your lease has ended, or if you are a month-to-month tenant, your landlord is allowed to increase your rent.
Oh, yeah. Wow. With COVID,
Yeah.
Hmm.
Well, thank you for your question. And did we have any other questions for Nareen before we wrap up tonight? All right, well, I think that is it, Nareen. Thank you once again. And thank you everyone for joining us tonight. I really appreciate everyone making the time on a very, very beautiful day for an informational program with the Arlington Heights Memorial Library. Everyone have a wonderful night, and don't hesitate to reach out to the Arlington Heights Library with your questions, or if they are legal questions, please direct those to Nareen.
Okay, thank you.
Thanks, everyone. Have a great night. I'm going to go ahead and end the webinar for everyone. So this Zoom window will close. Take care, everyone.